Hi students, hope you all are doing well. Welcome to another session of healthcare entrepreneurship. So today we are going to pick it up from where we left last time. So let's get started. And I have to make sure I deliver and I get a feedback from them, and based on that like in future they can spread a word of mouth and the product can get more popular. So this also creates a lot of like social media traction. So typically there is a nice video which is shot, nice and professional. So next let us take a look into this video. This is the link for this video. So from this video we will understand a snapshot of what the product is and what our offering is and how you can purchase it, right. So let's take a look. Okay, so the next topic which we are going to talk about is a very exciting topic which is known as intellectual property rights. Okay, this is something all of us should understand as an entrepreneur, right. So how we can protect our particular product so that it is not stolen or the idea is not copied and things like that, right. So property by definition can be either tangible or intangible. Tangible is something which we can touch and feel, intangible is something we cannot touch and feel. Tangible examples are movable, like which is like a car. Immovable properties like buildings, we cannot just move buildings. Out of intangible you have intellectual property. Okay, so intellectual property is a type of intangible property where it is basically bifurcated into two places, which is industrial property related or copyright related. Under industrial property related you have patents, designs, trademarks, and GIs are typically known as geographical indications. We are going to explain each of these, right. So let's dive in and understand what these intellectual property types are, right. So under the IPRs, like I've said, you have these different versions like trademarks, industrial design, patents, copyrights, geographical indicators. This gives you exclusive rights to a person over the creation of their minds for certain periods of time. So certain period of time is the keyword. So you only get protected for a certain period of time where you have this great idea or great product design or something like that, or process design. So you can have a property, intellectual property for products, processes, designs, ideas, things like that. And so by idea it has to be an established design idea or something like that. It's not like I was thinking that this is how a product could be and that can be patented. That's not how it is done, right. It has to have some levels of low fidelity MVP or a design at least to be covered under IPR, right. So these kind of things can be protected so that on a public forum nobody is able to steal these things, otherwise you can file a lawsuit or like fight against them like in the court of law and things like that. This gives you a legal right towards having that idea implemented in your products or your company where nobody else can take that. It's an intangible property, potential asset which cannot be touched and felt. You can create a monopoly using these kind of IPRs, as well as there are negative rights. It prevents the others from using this creation for a definite amount of time. Let's say you have this great idea with this in mental health, which is just upcoming in India, right. So you have this great idea, you want to protect this for the next 5 years and make sure that nobody can steal this great idea of an app or something, right, like which you are trying to build. So then that prevents any other company to dive into the space and explore a very similar idea. You can always file a lawsuit against them if they infringe into your space. So sometimes it is good to create a barrier where you do not want other players to join, right. So the intellectual property rights were essentially recognized and accepted all over the world due to some very important reasons. IPR rights are all well known around the world. This is not something which is Indianized or US specific. IPR rights basically provide an incentive to individuals for new creations, to accord due recognition to the creators and investors so that people do not steal each other's ideas or implement something, to ensure material reward for intellectual property, to make available genuine and original products. So, these are the 4 key mandates and objectives of having intellectual property rights, right. You want to make sure that people are rightly credited, right, and if somebody has really spent time in like developing something, they are getting royalties and things like that in the future, like based on this, right, and nobody else is able to claim it, right. So, various kinds of IPRs include patents, which are basically inventions in the forms of products, processes, materials or compositions. Sometimes it may be that it is a food composition, which I have applied as an invention under a patent. It could be a composition of a certain material, it could be a certain composition of a chemical or a drug constituent. These all can be patent protected, or a medical device design or a app design, right. Patents also cover technical solution to a technical problem or an industrial problem from an industrial standpoint. Let us say there is a very specific technical problem, like there is this particular catheter which you are using for a particular like urine collection or something like that, and this catheter needs to have a very certain type of tip for this urine collection, right. So, this tip design which you have created with certain innovation and new design, this is solving a very key technical problem which may not be well known to others who are not from that domain. So, this can again be protected by a patent. Then there are designs, which are external features appealing to the eye, like new shapes, patterns or configurations. So, origami, for example, you have this new pattern in which something opens up, or you have this new design which you think is a generic design for a better improvement of the chairs or better improvement of the medical devices in general. They come under designs, right. So, there can be a very thin line between the patents and the design, that what I have this nice MVP type of design, should I put this under a design or should I put this under a patent. So, typically if your design has gone to that stage that you are able to implement that and you have run some test, it is in the product phase, then only apply for a patent, otherwise you apply for a design registration, which is a little lower than the patent, okay. So, now hopefully this clarifies that just with your design, hand drawn design or some kind of CAD design or something, you cannot file for a patent per se, right. Of course, there are ways around it in which design can be implemented, it could be scaled down, you made a prototype and things like that, but typically you are looking for products, processes, materials and compositions under patents, right. Designs are separate, they are typically under design registration. So, I will give you an example. So, we came up with this new face shield design while we were trying to develop this new face shield for mass production, and we initially unknowingly filed for a patent, but it did not go through. So, they recommended apply for a design registration instead, okay. Trademarks, a visual symbol such as a word, name, logo, label, monogram or slogan which is particular to a product or a company. This is typically applied on the article of manufacture or service, right, indicates the origin of the goods and services. Trademarks like Coca-Cola, McDonald's, we have talked about trademarks quite a bit, right. Next, various kind of IPRs also include the copyrights. Copyrights are like artistic, literally musical and dramatic creations, right. So, if somebody has a nice YouTube video and somebody is trying to steal that video and use it somewhere else, then it is a copyright infringement. So, that is why whenever we showcase a video or showcase something or use it somewhere, we have to acknowledge the source of it and whether this is public information or not, right. Otherwise, just randomly taking something and using it somewhere else without acknowledging or citing where it is used from may not be the best thing to do. You may require permissions like several places, but open source things which are available to the general public, that you can showcase by just citing it, that is good enough, right. But several journal articles or things like which are protected under certain laws, you cannot just share them randomly, right. Or artistic things, like there is this artistic design which is there, you cannot just share it and copy it like 10 places and print it, right. Proprietary right comes into existence as soon as the work is created. So, copyrights can be developed as soon as the works are created. So, many a times you will see this is under copyright license CC 4.0, something like that. So, many a times people want to save their design, put it under copyright license, then you have to pay something to their for adapting to those designs. Many a times people will scan the image of the brain, image of the artery, place them online, but it is under a copyright license. So, you cannot use them directly. You have to now pay them or take the permission, right. Otherwise, in certain cases there are just open source licenses. So, that is where you do not have to care. Open source is something which is public information, can be used by anybody, right. So, things like YouTube and other public information items are usually open source. Geographical indications, that is the next one, which is basically identifies agricultural, natural or manufactured goods originating from a definitive territory in India. So, geographical indicators are specifically sometimes manufactured goods or specific things which are specific to a country. This possess special quality or reputation based upon unique characteristics of geographical location. So, certain things are very native to a certain place, right. If all of a sudden somebody in somewhere in Europe claims that homeopathic medicine, like this particular medicine is coming from somewhere in Europe, they cannot do that, because homeopathy by geographical indicator is majorly belonging from India, right. This may have a different origin in certain places, but there are certain geographical indicators. So, I will take an example of all these like as we go along. So, before we do that, the organization structure, majority of these patents and trademarks and all these design registration, geographical indicators are typically governed by the Ministry of Commerce and Industry, right, under the Department of Industrial Policy and Promotion, right. Under them you have the Controller General of Patents, Designs and Trademarks. Within this you have the Patent and Design Office. They are typically in Kolkata, Delhi, Mumbai and Chennai, and I may not be aware of the latest developments. They may be in the bigger cities as well. The trademarks registry were earlier, as per as for the best of my knowledge, were in Mumbai, Kolkata, Delhi, Chennai and Ahmedabad. Then geographical indications registry was specifically in Chennai. I do not know the latest development, it may have been there in certain other places. Then you have patent information system. There is one in RG and IIPM, and then the next one is Nagpur, right. So, these are some systems and how things are delivered throughout the country, right. So, this is based on public information which I have taken, and I think this may have some updates which is not the latest which I have, right. So, validity of an IPR. So, typically an IPR like patent can have a validity of 20 years. Renewal is mandatory on a yearly basis, so it is an annual renewal. The act or rule which under which the patents come is the Patents Act 1970, amended in 2005. So, that is as far as the latest public information is concerned. Trademark is typically lifelong and has to have a renewal after 10 years. The Trademarks Act of 1999, amended in 2010, is what is typically followed unless there is a latest one. Designs are typically having a maximum protection of 15 years. After 10 years you need to renew them for next 5 years, right. So, this comes under the Designs Act 2000 and Designs Amendment Rules 2014. Copyrights will have a maximum protection of 60 years and they do not require any renewal. This comes under the Copyright Act 1957, amended in 2012. Geographical indication is also lifelong and typical renewal is after 10 years. The Geographical Indications of Goods Registration and Protection Act 1999 is what it comes under, right. Another thing to know is patents will cease and will be transferred to public domain if patents are not renewed within 6 months of expiry of concerned year by paying renewal fee. So, many of the patents you will search are expired, and if certain companies are eyeing for having a new technology or working on a new technology where there was a patent for the last 10 years, sometimes they are looking at the patent expiry as a new startup. So, let us say the patent expired in 2020, 6 months after they have the parent company forgot to pay for the patent, or there has been some other issues like why the patent was not renewed, the startups can now start jumping into it legally, or maybe file a advanced patent on that, right. So patents usually get expired if they are not renewed within a 6 months duration. That's as far as the best of my information, right. So let's talk about some relations between the IPRs. For example, the logo Coca-Cola is an example of trademark. Okay. Shape of the bottle is an industrial design. So within the same product, you are looking at several different IPRs. The shape of the bottle is a very key industrial design. Patent may have been obtained in respect of the bottling equipment. So the equipment which is used for making these kind of bottles or assembling the bottles, there may be a patent on that, right. Copyright, in respect of the text, database of artistic work appearing on its website may be part of the copyright, right. So a lot of information which is part of the or slogans or things like that may be part of the copyright, right. A single product basically can be protected by more than one types of IPR. This is just an example to showcase that. Some other examples are, for example, you are looking at this fan where there is a component of industrial design, and the top part there is a material or a certain structure which is built, which is protected with a patent. So there is an industrial design come with that you have a patent. On an iPhone you are looking at patent for the design and the particular product, as well as you have the Apple trademark which is there. One geographical indication example is Tirupati Laddu, for example. So this particular laddu or type of laddu cannot be claimed by anywhere else in the world. This is a clear geographical indicator, right, like it has been properly filed for. So many of these things are not properly filed for, and they can have like a gray area, right. The Coca-Cola, where I have explained that the bottling can have a patent, then there is a trade secret which is the kind of composition which is there, which can also come under the patent. Then there is the industrial design which is the bottling, and then you have the trademark, right. Another geographical indication is Kolhapuri chappal, right. This is very common, specific to India in a certain region, right. Homeopathy is another example which I gave you. More things about patents: it's the exclusive right of an inventor to prevent others from possessing, using, selling, manufacturing and importing the patented invention or offering to do any of these in definite geographic area. The keyword here is geographic area. One thing we have to understand is patents have territorial jurisdiction. We have to register the patents in all countries where we have our interests. So typically a patent filed in India does not mean the particular product design or product know-how is protected in the US. Somebody can start this in the US. So if you feel like your product can get popular in the US, you need to file for an Indian patent, you want to file for an US patent. Yeah, there are certain patents which cover several other countries or multiple countries together, like it's an international coverage of several countries, but typically it is jurisdiction specific. So many a times you may be filing a patent for something in India, and all of a sudden you can see China or some other country copy it. Then you may not be able to fight for it because you have not filed a patent in their jurisdiction, right. So this is something to keep in mind. So patent application can be filed online in India by inventor or as assignee. So typically patent filing incurs a cost. So if you are filing it through an agency, they would typically have a lot of markups and prices for legal fee, because patents are typically written in a legal language and has clear ideas of the claims and different aspects, like which many of us may not be prepared to write it by ourselves, right. But having said that, you can actually file for your own patent, like by paying a certain minimal amount of fee if you are part of a startup, if you just learn how to write a patent and things like that. But majority of the times they are done through some kind of third party agencies who already have a template and they clearly know how to file it, what are the key aspects. It's just like filing any other things, like filing for your company. It's very similar, right. You could do it yourself. it would take you a longer duration and probably a know-how about what the steps are, or you could outsource it to somebody or a CA or a company which can take care of it, and of course it will incur a cost, right. So ipindia.nic.in, this is the website from which you can look at filing of the patents. Patent is an exclusive monopoly right granted by the Government of India for an invention to the inventor or his assignee as a territorial right in lieu of the disclosure of invention to the government, right. So, you have disclosed the invention to the government and the Government of India has given you the right to protect that. The term of the patent is typically 20 years from the date of filing. Yeah, this is the latest information which I had. This may not be the latest value, right. Trends in patent applications, these are some typical trends, and I just have the information till 2018 here. So, we are looking at an overall increasing trend of patent filings, like as these are getting more and more popular, a lot of institutions like IITs and like NITs and several other government and private institutions are also filing a lot of patents these days, which was not very common, like let us say 10 or 15 or 20 years back, right. Majorly patents would be filed by companies, to protect their products and things like that, and individually or startup based patents were not very common because they were expensive. Now things have been kind of monetized in a way like that the prices have gone down, but like the filing is still a challenge, but like many a times like you could have some very simple filing agencies which will file for you, right. But overall trend, if you look at the patent applications, they have gone up quite a bit, right. So, on a yearly basis, we are looking at the blue symbol as the filed patents, then examined, granted and disposal, right. So, granted are much lower than the filed ones, right, or the examined ones. So, typically what that means is, it does not necessarily mean that you file for a patent that you will be granted a patent. This is examined through through the right due diligence, and there is an examiner, they have a peer review, and based on that they reject a lot of patents based on no novelty or the claims are not correct. There is a similar patent or similar product out there which you have not considered. So, due to reasons like this, patent filings get like not granted, right. So, if you look at the filing, examined of course is very high, granted is much more lower, and disposal is disposed of, right. So, as per the Patent Act and rules in India, patent rights are governed by the Patent Act 1970. At present, the third amendment of the act known as the Patent Amendment Act 2005 is in force. I think that is the latest information from as what I have. For application of Patent Act, rules are made by the government which are known as the Patent Rules 2003. As of now, Patent Amendment Rule 2006 and further updates to September 2015 are in force. So, this was the information which I had a year or two back. So, this may be updated. So, yeah, just look at the latest public information. This is some information which I have collected from the public sources a while back, right. So, this may not be the most updated. But for better understanding of acts and rules, draft manual of the patent practice and procedure MPPP 2008 is made by the patent office. So, there are several draft documents which clarifies you a lot of doubts and questions which you may have with the patents. There are 4 patent offices in India having work distribution according to their geographical location like Kolkata, Delhi, Mumbai and Chennai. These are the main metropolitans, right. So, the typical criteria for patentability is novelty. So, the word novelty is something new which has not been done previously, right. Inventive step, or it must be non-obvious, right, capable of industrial application. If it does not find any industrial application, just you are trying to take a patent for the sake of it, it will not be granted, right. Not fall within the provision of section 3 and 4 of the Patents Act 1970. So, there are very specific segments under which it is not considered for patents. So, what is section 3? List which are not inventions, like frivolous or obvious things, right. Sometimes companies would or individuals would like to steal some ideas and somehow by hook and crook try to patent it, right. So, if something of that sort is found, like they are not examined, or sometimes like they will not be granted or rejected, contrary to well established natural laws, something which is very kind of like, it could be innovative but doesn't justify or doesn't make any sense. So there are like so many design ideas or things like which people may come up with, which just is completely different from the normal norms or what technical aspects we know of, right. Injurious to public health. If you are trying to patent anything like any illicit drug kind of products and things like that, which is injurious to public health, they will not be examined and will be rejected. Mere arrangement or rearrangement. Sometimes we want to use a few parts, rearrange them and say we want to file for a patent, right. That is not accepted. Discovery of a scientific principle. So, if you have come up with a new scientific principle, that may not be patented, right. Discovery of a living thing or a non-living substance in nature. So, many a times many like animals or like particular insects and certain new living things are discovered, and non-living substances like materials, some metals like, or which are naturally discovered. So, those discoveries are not covered under patent. So, you cannot go there and say ki I have discovered this nice salt rock or some kind of like rock which is some mineral or something like that. So, you cannot, that is all public property, right, government property. Method of agriculture or horticulture, this is another area in which you cannot patent it, right. A mathematical or business method or a computer program. So, lot of us who are trying to create a computer program or a coding, that cannot be patented under the Patent Act. Good to know, right. Section 4, non-patentable is atomic energy related. Anything related to atomic energy cannot be patented. Ornamental or aesthetic aspects of a useful article for the industry. This is for the industrial design. Aspects that give special appearance, aspects which differentiates from current products, only the aesthetic and visual form of the product, not the technical. Technical things are covered under the patent, but an industrial design or a design registration is like something which is visually different from what has been seen so far, right. So, trademarks could be possibilities of distinguishing other features. The ornamental or aesthetic aspects of an article consists of three-dimensional features such as the shape, surface, texture of an article, two-dimensional features such as patterns, lines or colors. These kind of things come under design registrations, right, or industrial design. Design makes the product attractive and appealing to the customers and adds to its commercial value. So, many of these are placed as design registrations. I have already shared an example. Some more examples are protection. Typically you have an exclusive right against unauthorized copying. Protection normally lasts for an initial 10 years, after which it is usually renewed for, in most cases, up to 15 years. Here are some examples like jewelry design, like certain designs for chairs, right. They are not proven, they are not proven products, but these are new designs. So, an architect can design so many things of his architecture, but does not necessarily mean this is patentable, right. So, this can have a design registrations like the Lamborghini or a car design, right, or a shoe design, apparel design, bottle design. Trademarks, generally brands or logos, a visual symbol which may be a word, signature, name, device, label, numerals, or a combination of both colors used by one undertaking on goods or services or other articles of commerce to distinguish it from other similar goods or services. We have talked about trademarks previously. Any name which is not unusual or for trade to adopt as a mark, right, device or symbol or a monogram. So, Coca-Cola, McDonald's, in particular like plus symbol for certain trademarks, shapes and goods of their packaging, combinations of the colors. So, a lot of these things add to the trademark. These are some examples, right. We are looking at all the different trademarks like McDonald's, Honda, Coca-Cola, BMW. These are quite well known. From a trademark, patents and design standpoint, if you look at the amount of filing, you will be very surprised to see there are more trademarks filing, significantly more compared to patents and design. So, this is where many of the companies are trying to stand out by saving a trademark for their particular product rather than going for patents, because many of the things people cannot steal, but trademark is something which they want to retain, right. So, copyright is a legal term describing rights given to creators for their literary and artistic works. The works covered under copyright includes literary works such as novels, poems, plays, reference works, newspapers and articles. Good to know. Computer programs and databases. This is what comes under the copyright, all your codings and all, right. Films, musical compositions, dance, theatrical productions, artistic works such as painting, drawings, photographs, architecture, advertisements, maps, technical drawings and manuals, right. Copyright comes into existence as soon as the work is created and protects skill, labor employed by the creator in production of the work. So, you can have like a generic copyright, like you do not have to always register for a copyright, right. Terms of a copyright. So, if life of an author, like 60 years from the beginning of the calendar to the next following year. So, this is just a comparison of how much a copyright holder can hold in US, India and most of the other countries. So, India is somewhere in between the Europe and most other countries, right. Geographical indicators identify agricultural, natural and manufactured goods associated with a certain territory. At specifically given some examples, the manufactured goods should be produced or processed or prepared in that territory. This gives a special quality to that product due to geographical or climatic environment, reputation, specific manufacturing, farming skills, traditions and other characteristics attributable to the origin. It consists of the name of the place of the origin or originates from a definite geographical territory, like Darjeeling tea, Kanchipuram sari, Kolhapuri chappals, Tirupati laddu, Nagpur orange, homeopathy. So, these are some examples, right. So, this is an example of geographical indicators like the basmati rice, and these all things are specifically native to India, right. Like this, nobody can just come and steal and claim it. So, with that, I would like to thank you all. Hopefully, you have learnt quite a bit about the different techniques of commercialization and the IPRs, what needs to be there. Stay tuned for more exciting lectures in commercialization module where we will learn about the business proposals in the upcoming.